Hello, and a warm welcome to the EDRM Global Webinar channel. My name is Mary Mack. I'm EDRM CEO and Chief Legal Technologist. Today's webinar is a collaboration with our trusted partner, eDiscovery Today, titled Important eDiscovery Case Law Decisions for January 2026. Our faculty experts are Doug Austin, Tom O'Connor, and the Honorable Judge Andrew Peck and myself. We are recording today's session for future on-demand access, and slides will be available after the webinar. And this webinar, along with all our EDRM webinars, will be available on the EDRM Global Webinar channel for the next quarter to help support your ongoing learning and reference needs. And questions will be answered both during and at the end of the webinar. Holly Robinson, EDRM Senior Marketing Operations Manager, is here with us. Holly, can you please share what resources are available today?
Thanks, Mary. And we are loving On24 with so many ways for you to engage. If you look at the bottom of your screen, you'll see the console. The question mark icon is where you can type your questions for today's faculty, and we highly encourage you to do so. You'll also see the paperclip icon. If you click on it, you'll find today's resources. You can download the On24 engagement tool descriptions to help you better engage with the platform. There's a link to subscribe to eDiscovery Today blog, an excellent way to stay informed every day. You'll also find a link to learn more about the Honorable Judge Peck and how you can engage with him. Right below that, there's a link to get your copy of the new book from Tom O'Connor and NextPoint, Artificial Intelligence for the Rest of Us, which is their latest project following their earlier collaboration, eDiscovery for the Rest of Us, the Checklist Manifesto. You'll also see a registration link for next month's case law webinar, Important eDiscovery Case Law Decisions for February 2026, happening on the 16th. We'd love to have you join us again. And be sure to register for our upcoming webinar happening this Thursday, Truth on Trial, How to Detect and Challenge Deepfake Evidence in the AI Era, with Doug Austin, Brett Burney, Dr. Felix Hernandez, and the Honorable Xavier Rodriguez. If you'd like to learn more about today's faculty, click on the speaker bios, and they'll pop open with more details about our presenters. And just like on Zoom, you'll see the smiley face emoji and lots of other reactions. We highly encourage you to use them throughout the webinar. Finally, click the LinkedIn logo to follow EDRM and eDiscovery Today on LinkedIn. Back to you, Mary.
Thanks, Holly. And all opinions expressed here are our faculty's own, not those of their firm or clients, and no legal advice is being provided. And today's faculty, we've got, of course, Doug Austin, the editor of our trusted partner, eDiscovery Today, a daily blog about eDiscovery, information governance, cybersecurity, data privacy, and artificial intelligence trends, also including best practices in case law. Doug is an established eDiscovery thought leader with over 30 years of experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and governmental clients. Doug has published a daily blog since 2010 and has written numerous articles and white papers, receiving the J.D. Super Reader's Choice Award as a top eDiscovery author and a top cybersecurity author. Doug has presented at numerous webcasts, events, and all of the best conferences. We also have Tom O'Connor, the director of the Gulf Coast Legal Technology Center. Tom O is a nationally known consultant, speaker, and writer in the area of computerized litigation support systems. His consulting experience is primarily in the complex litigation matters where he's worked with firms of all sizes. He's also been appointed as a technical consultant by various federal and state courts on cases dealing with large amounts of electronic evidence. Tom, with Rocky Messing, hosts the Discovery Channel on YouTube, and he's the author, as Holly said, of Artificial Intelligence for the Rest of Us and the eDiscovery for the Rest of Us, the Checklist Manifesto. And the Honorable Judge Andrew Peck is a Band 1 Chambers-ranked senior counsel at DLA Piper, serving 23 years as a U.S. magistrate judge for the Southern District of New York. And before his appointment to that bench, Judge Peck was in private practice, focusing on commercial and entertainment litigation, including copyright and trademark matters, with extensive trial experience. And at DLA Piper, Judge Peck advises on IP and also serves as a resource for the firms and its clients on litigation strategy and discovery issues, information governance, and cross-border discovery from a judge's perspective. Sought out as a conference speaker concerning eDiscovery issues, Judge Peck has been retained to serve as a special eDiscovery counsel to clients and law firms and to submit expert reports on eDiscovery issues. And EDRM is grateful to all three gentlemen for their service on the EDRM Global Advisory Council. With that, Doug, do we have some cases to kick off the year?
We do indeed. So many that I have to clear my throat before we get started here. Yes, thanks, Mary, and welcome everybody to our first case law webinar for 2026 on the EDRM network. We do indeed have 6 unique cases to discuss this month, and as you can see, the topics are right there, and we'll get into each of those shortly. We'll save a little time by jumping on ahead. Of course, we do welcome questions, and we'll try to get to as many as we can, and we'll send a copy of the slides out after the presentation, so look for that too. As Mary mentioned, of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. Disclaimers may be boilerplate, but they're never waived. And here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Minerva 26, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and e-discovery terms. Minerva 26 has over 45,000 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. Minerva 26 is the definitive source for e-discovery case law out there. So with that said, let's get into the cases. This first dispute, which was suggested by Judge Peck and covered by our friend Michael Berman, originated after the court granted Jami's ex parte application under 28 U.S.C. 1782, authorizing Jami to issue subpoenas to Celerity for documents and testimony relevant to the German proceedings. Celerity responded not by producing documents, but by asserting sweeping objections and stating that it did not presently intend to produce documents in response to any of the 10 requests for production. Needless to say, but I'll say it anyway, Jami moved to compel, citing urgent deadlines in the German litigation and arguing that Celerity's objections were meritless and dilatory. Texas District Judge Amos Mazant found that Celerity had waived most of its objections in 2 fundamental ways. First, by qualifying its responses with subject to language, and second, by relying almost entirely on general or boilerplate language. Judge Mazant also described the use of subject to objections as manifestly confusing at best and misleading at worst, explaining that such language leaves the requesting party uncertain as to whether the question has actually been fully answered and makes it impossible for Jami or the court to assess the sufficiency of the response. By using this formulation, he said, Celerity waived each objection. He didn't think much of their privilege assertions either, finding that because Celerity failed to provide a privilege log or substantiate its claims, Celerity had waived privilege and work product protection, although he declined to order production of privileged materials given Jami's representation that it did not seek them. And Celerity's proportionality, undue burden, and overbreadth objections were also waived, as they provided no manner and extent of the burden, making them, as Judge Mazant stated, nothing more than an unsustainable boilerplate. He also found that producing nothing in response to discovery without a privilege log or a motion for protective order is not an option, and characterized Celerity's conduct as a clear attempt to delay and deny discovery, ordering Celerity to comply with the document subpoena within 7 days. He did, however, modify the subpoenas to ensure compliance with Rule 45's geographic limits. So, Tom, why would a party respond to a group of document requests by stating they don't presently intend to produce documents? Is this a strategic move or a lack of understanding of civil procedure rules?
Well, I think it's, first of all, it's a lack of understanding of Judge Peck's Rule 1.1, that, you don't lead with that language Especially after you've had some, there were some filings in this case. They had the ex parte application and they appeared, and they maybe could have raised some of that then. But this was, at first I thought maybe they're just not clear on some of the civil procedure stuff, because if you read the judge's opinion, they raised the European issue a few times, and I thought, well, maybe they're confused, but it's just across the board. I mean, what you've got there talks about several of the things, the boilerplate language. I particularly like the judge said their use of the phrase "to the extent." His quote is, "Their use of the phrase "to the extent" without specifying what it means does not extend to anything." If you're going to say,
Right.
if you're going to say "to the extent," you're going to tell me what extent you're talking about, which they didn't. And then they also, if you read the opinion, they cited two cases which he looked at in depth. It's a nice, in-depth opinion about each of the points in the objections. He said, "I don't know what these cases are doing here. These cases don't seem to have anything to do with the dispute that's in front of us." So, all in all, I thought the judge's case, or the judge's greatest comment was, quote, "In its attempt to cover all its bases, celerity covers none," end quote. It was just like, fail, F. This isn't even like a D-. This is like an F.
Yeah, absolutely. And yes, it was a pretty lengthy opinion because there was a lot for the judge to say about Celerity's response. So I'll turn to Judge Peck. So Judge Peck, is it possible that Celerity didn't understand the significance of Jami's ex parte application under 28 U.S.C. 1782 as a reason why they were entitled to discovery for the German litigation? Because surely they know by now that boilerplate objections result in a waiver of those objections, right?
Isn't that where we say, "And don't call me Shirley"?
Indeed.
But, I do fear that too many lawyers, even in straight domestic cases, not the 1782 type cases, are so used to using boilerplate objections that despite the change of the rules, despite, all the cases criticizing boilerplate objections, including in the Southern District in New York, my Fisher against Forrest decision, they are still used much too often, almost every day in litigation. And I think the 1782 type litigation makes it even more out of the ordinary for the lawyers here. But it almost sounded to me like this was a stall tactic, with all these objections and not producing anything, and, not only not producing, but blatantly saying they don't intend to produce anything, sort of like waving a red flag at the bull. But since the purpose was getting this material for a German litigation that was near to, happening, they may well have been trying to run out the clock here. One thing I would point out on the privilege objections and what's boilerplate and what's not is it seems to me that something saying in one's initial response, "I am not going to produce any privileged material. I'm not waiving privilege, period." And then, however, once there is going to be some production, producing a appropriate privilege log. But at the beginning, when you're just responding to the request, you don't really know what is going to be called for, what's going to be privileged or not. So I have no problem with that open-ended, we're not going to give you anything privileged in the beginning, as long as at the time of production, as opposed to the time of not intending to produce, you do a privilege log.
Yeah, no, that makes perfect sense. So, Mary, how should Celerity have responded to Jean-B's request for production as a non-party, because they are a non-party in this case, to minimize their burden while still meeting their obligation to respond?
Well, I want to give a shout out to them because my goodness, 1782. I mean, how many U.S. practitioners understand what that even is? And then they're a non-party. But they answered, and they answered with boilerplate, which was not very good. So my suggestion would be to consider having their own meet and confer, and address some costs and protective orders there, or offer the 502D, but mostly don't just use words and wave papers. You have to use numbers to demonstrate the cost and time of an expense of complying. You can sample, so you can use more precise numbers, and you can demonstrate that the ESI sought is not relevant, it's marginally relevant or duplicative of already produced information. You've got to know what's out there. So hopefully you've got a production repository somewhere that you can take a look and see. And don't cut and paste. even if that's what you're intending to do, find a way to say it differently so that you can give them something that distinguishes your answers from each other and shows that you've actually considered the question and applied it to the facts and the law in your case.
Yeah, those are all great suggestions. Question from Sheila Grilla is to the extent bad wording or incomplete work, it's hard to tell, overdone or not done as to objections. It is a hard rule that specific objections are tailored, objections are mandated to protect the client. Thoughts on that?
If only more lawyers paid attention and followed Sheila's suggestion.
Yeah. I think it's both bad wording and incomplete work, right?
Yeah.
I mean, obviously you can use the phrase to the extent, but there's words that have to go after that.
Right. Yeah. This case seems to be a poster child for how not to object. So definitely a good one to show us that example. And we'll move on to the next case. In it, the parties had previously disputed the number of custodians that should be allowed under the ESI protocol. Plaintiffs wanted 25, and each defendant sought a limit of 5 custodians. And California Magistrate Judge Lisa Cisneros ruled that plaintiffs could designate up to 12 custodians per defendant. When defendants sought relief from the ruling, District Judge William Orrick denied the request, stating that a defendant may seek a protective order from Judge Cisneros if a particular defendant believes plaintiffs are abusing the designation process, which became the crux of the current dispute. Regarding defendant Deviant Art's opposition to plaintiff's request for 4 document custodians here, Judge Cisneros stated, DA must establish good cause for a protective order on grounds such as unreasonably cumulative or duplicative discovery or based on annoyance, embarrassment, oppression, or undue burden or expense. The stipulated ESI order, however, would not advance efficiency if defendants were allowed to easily sidestep their general obligation to produce document discovery for up to 12 designated custodians by requiring plaintiffs to seek an order to compel and demonstrate that the custodian will have relevant information that is proportionate to the needs of the case. As Judge Orrick has made clear, the appropriate balance requires an objecting defendant to seek a protective order by demonstrating that plaintiffs are abusing the designation process. Continuing, she said, discussing the relationship of the 4 custodians to the case, which you can find in the link to the case, the idea that responsive documents will necessarily be found in other custodians' records is not sufficient to defeat a search of his files. Rather, it is possible that one custodian will have a document or documents that other custodians have not retained or do not possess, particularly where custodians are on different rungs of the corporate ladder. Although there may be overlap between Surovenko and Gorniak's custodial files, it is likewise reasonable to expect that Surovenko was privy to communications and documents that his supervisor or other high-level employees did not possess. Moreover, DA has not demonstrated that plaintiffs seek to include Surovenko as a custodian for abusive or oppressive purposes. So, Judge Peck, I'm surprised we haven't covered more disputes regarding the scope of custodians. Did you ever have to rule on disputes like this? And if so, what did you look for the requesting party to grant their request?
I did have to rule on that, probably not as much as certain other issues, but which custodians was indeed an issue in front of me. As to how I dealt with it, first, broadly speaking, look at proportionality. How many custodians would be just numerically appropriate based on the dollar amount at issue or other of the proportionality factors. Second, when we get from the number of custodians in general to specific custodians, why should a particular custodian be included or not? The requesting party should show the role of that custodian based on their dealings with their adversary or other information sources, the corporate org chart or other things. The responding party, on the flip of that, has to show why a particular custodian would not be appropriate. Would that custodian's data be duplicative of others? Would it be so duplicative that it's not necessary, etc.? Finally, with respect to the Rule 26A identification of witnesses and document sources, identifying a witness as somebody who may well be called upon to testify favorably for you at trial is not the same as saying who is an appropriate custodian. Somebody who is identified as a potentially testifying witness probably does mean that their documents are, going to be reviewed. But it doesn't give any indication about who else should or shouldn't. In the old days, with certain high-level employees who didn't do their own emailing, I know, hard to believe, the fact that, employee X is identified doesn't tell you whether employee X's administrative assistant needs to have his or her documents looked at, etc. It is not a one-to-one overlap between the 26A disclosures and who are the appropriate custodians.
Yeah, no, that makes sense. And yeah, we'll get into Rule 26A in another case here in a bit. So Mary, what, if anything, could DeviantArt have done to make a better case that plaintiffs were abusing the designation process and requesting those 4 custodians?
Well, the roadmap is put out. You had mentioned it before. You've got to establish good cause for a protective order on the grounds as unreasonably cumulative or duplicative discovery or based on annoyance, embarrassment, oppression, or undue burden or expense. And I'd just make a note here that the cumulative and duplicative and the burden and expense, those are fairly objective, non-emotional kinds of arguments you can make. But to have to go to court to talk about the annoyance, embarrassment, or oppression, of the particular custodian, you're kind of putting them in the spotlight to make them not be in the spotlight in the case. So I find that a little bit difficult to protect your custodians. But I guess the lesson in this is to control your own destiny and don't let the court write your protocols and know what you're agreeing to.
Yeah, absolutely. And yeah, I mean, they did try to make a case that these 4 custodians were marginally relevant, but that didn't meet the demand of showing that this plaintiff sought to include them for abusive or oppressive purposes. So they didn't get what they wanted. So Tom, given that the producing party knows more about their custodians than the requesting party, what can the requesting party do to help ensure to maximize inclusion of relevant custodians in discovery?
Well, I think Judge Peck just noted some of the standards you could use, a little checklist, if you will. I mean, the bottom line is this is my summary of it, but custodians are supposed to have relevant information proportionate to the needs of the case. Okay, so that's what you want to establish. But remember, this is a little bit different because there was a stipulated order regarding discovery, which they had seemed to get along with. They had gone back and forth and tried to work stuff out, and then went to the court, and they had that approved by the court. It was only this issue of the custodians that was giving them some problem, but they went to the magistrate judge, and Judge Cisneros ruled. I think the plaintiffs wanted 25, the defendants sought 5, right? Limit of 5. And so she said 12. Okay, so they then appealed that up to Judge Orrick, the district court judge, who said no and kicked it back down and said, as Mary just pointed out, your standard now is you've got an order. The standard now is, can you show that this is somehow abusive? So it got ratcheted up to a different level, if you will, and they didn't. I mean, the judge made clear what that standard was, and Judge Cisneros said here, DA has not made such a showing. So that's it.
Yeah, that is it indeed. And it'll be interesting to see if we have more custodian disputes like this, because I definitely think this is an area that, happens a lot. So this was an interesting case to get into from that standpoint. And we'll move on to our next case, which is the first of 2 Yogi Berra deja vu all over again cases we're discussing this month. This one we've actually discussed 2 times previously. And as our own Judge Peck once said, the use of tar is not a Staples easy button, which this case certainly illustrates. At the heart of the dispute was the initial plaintiff's use of a tar/cal process to identify responsive documents in August 2022. After producing fewer than 18,000 documents, plaintiffs represented that their productions were substantially complete. Walgreens challenged the adequacy of those productions, pointing to a prior closely related litigation against CVS, in which a subset of the same plaintiffs had produced approximately 140,000 responsive documents, a lot more than this case. When Walgreens later identified responsive documents from the CVS matter that had not been produced here, plaintiffs conceded that those documents had been scored below their 64-point responsiveness threshold in their tar system, which is, as our friend Dr. J. Jeremy Pickens pointed out, sounds more like a TAR 1 approach than CAL. By March 2023, initial plaintiffs had produced over 280,000 additional documents and claimed again that they had officially declared substantial completion of document production, which was still disputed, leading to motions to compel, with initial plaintiffs ordered to pay Walgreens attorney's fees and expenses, and ultimately the appointment of Special Master Moore R. Grossman. After conducting a preliminary diagnostic protocol, which we covered a couple of years ago, Special Master Grossman warned that plaintiffs' results raised serious questions about the adequacy of their productions and highlighted a huge discrepancy between the number of responsive documents plaintiffs expected to find and the number they actually produced. She also questioned how plaintiffs could possibly have declared their original production substantially complete under these circumstances. Those concerns ultimately led to a court-approved remediation protocol, which we covered about a year and a half ago, under which Walgreens reviewed document samples, coded them for responsiveness using plaintiffs' own definitions, and retrained plaintiffs' TAR model accordingly. By the end of the remediation, Walgreens had identified more than 77,000 additional responsive documents. Illinois District Judge Virginia Kendall emphasized that Rule 37A5A is presumptively mandatory when a motion to compel is granted, noting that it presumptively requires every loser to make good the victor's costs. Noting that initial plaintiffs produced less than 10% of the responsive documents they expected to find in their initial production, inexplicably narrowed their coding criteria for responsiveness during the review, made simple math errors, and failed to manually review over 500,000 documents they excluded from the TAR process. She said initial plaintiffs never addressed Rule 37A5A in their 35-page response brief, and nowhere in their brief did they argue that their actions were substantially justified or that an award of attorney's fees under Rule 37A5A would be unjust. So they have forfeited their objections to sanctions under this rule, which basically meant that those sanctions were awarded, later to be awarded nearly $400,000. She denied all other sanctions sought by Walgreens and also denied initial plaintiff's motion for sanctions, where they alleged that Walgreens manipulated the special master process to its benefit, stating initial plaintiffs spend a bulk of their 35-page motion reciting grievances about the terms of the remediation protocol, which they participated in drafting, and the delays and costs associated with this process fall squarely on initial plaintiffs. So, Mary, while we don't know all the reasons why, it's clear the initial plaintiff's TAR process seemed to be considerably flawed, given that they initially produced fewer than 18,000 documents, but subsequently had to produce more than 350,000 additional documents. So what do you recommend to our audience to minimize the risk of such a severe underproduction of relevant documents?
Well, certainly that 10% number that you had put out there, that the plaintiffs produce less than 10% of the responsive documents they expected to find in their initial production, that would be something that should make you go back to the drawing board. But drawing on the other case we discussed, the previously produced productions are a wonderful quality control gift, a training gift, and it's a good faith production gift. And so you can, if you've already redacted for privilege and issue coded something, it's demonstrably easier to make those productions. That would jack up the numbers. If you have a witness that doesn't have any more email in their email box for some unexplained reason, you can always do the friends and family method of looking at a communication matrix, see who they communicate most often with, that has a nexus to the case, and get emails that way. I mean, there are ways to beef things up, but certainly in the TAR process itself, there were severe flaws in there, and that I would say would be they should get the right experts in there to help them out. It's not an easy button, as you pointed out, Doug.
Right. No, it's not. And ultimately, they had to bring on a special master to kind of help, coordinate that process. And certainly, I think I would also add, sampling of the null set, the documents that weren't included in the production, to kind of use that as a chance to see what you're missing. So definitely some mistakes that were made there for sure. So Tom, do you think that an award of attorney's fees and costs, even if it was nearly $400,000, was enough of a sanction here?
Well, I think at first blush, I thought, no, that seems kind of odd, but Judge Kendall did a great job of analyzing the request for sanctions and her eventual award. And overall, she said, quote, a key purpose of awarding fees and expenses under Rule 37A is to deter abuses of the discovery process. And she felt that the, end quote, sorry, and she felt that the $400,000 was sufficient for that. She did go on to say the additional sanctions that Walgreens sought, dismissal, preclusion of plaintiffs obtaining damages and costs and adverse jury instructions, are either not warranted or not available under the law. She felt dismissal was too draconian. She felt that adverse instructions were unwarranted, given that the plaintiffs had eventually cured their deficient production sufficiently. And as far as not available under law, she said plaintiff signatures on the August 2022 joint status report are not a certification under Rule 26G, a little procedural point here, that applies only to discovery requests, responses, or objections. Putting it into this joint status report was not acceptable. So good discussion. I think if you read her opinion, really good discussion of why she went with the sanction she did.
Mm-hmm. Yeah, and I agree that those would have been would have been too much, even despite the mistakes that were made. So Judge Peck, it took over 3 years after the plaintiff's initial production to get to this point, including appointing a special master. So what, if anything, would you do as a judge to expedite correcting the issues associated with her TAR approach?
Deadlines, deadlines, deadlines. Nothing, convinces parties to get something done like having the court tell them you must do this by X date. I don't know that there was a sufficient deadline imposed even with the remediation process approach. I would also, to make sure that things were staying on track, require regular status reports and perhaps regular status conferences. Nothing like telling the lawyers that they must appear in court, not remotely, Friday afternoon at 4 o'clock every week or every month to get them to take the process seriously. So nothing like a good deadline and sufficient reporting so that it's, not like you gave them a 1-year deadline and on the 11th month of that year, they say, oh yeah, we've done nothing over this time period. Regular reports.
Yeah, absolutely. And that's, that certainly can avoid cases being drawn out like this one was. And since we have a deadline to complete 3 more cases, I'll move on to the next case. Which in that case, California Magistrate Judge Susan Van Keulen addressed a recurring discovery dispute concerning whether Anthropic was entitled to obtain certain investigative prompts and outputs generated by the plaintiffs during their investigations into alleged copyright infringement by Anthropic's Claude AI system. Judge Van Keulen analyzed the dispute in 3 distinct parts. For the post-suit investigation, she concluded that the publishers had indeed placed the investigation itself at issue. The publishers acknowledged that they intended to call their investigator and client witnesses to testify that even after guardrails were implemented, they were able to elicit infringing outputs using prompts that, quote unquote, anyone could do. According to Judge Van Keulen, such testimony necessarily invited scrutiny into how those results were obtained, raising unavoidable questions about what the successful prompts look like compared to unsuccessful prompts, whether the investigators engaged in jailbreaking, and whether the prompts were ones that ordinary users would submit. As she explained, if a witness takes the stand and asserts that he was able to elicit infringing results from Claude notwithstanding the guardrails, Anthropic must be able to effectively cross-examine him. So she granted Anthropic's request for production on all prompts and outputs, both positive and negative, used by investigators and client witnesses in the post-suit investigation, but denied the request for attorney-crafted prompts. Different ruling for the pre-suit investigation. Here, Judge Van Keulen agreed that, unlike the guardrails inquiry, the precise substance of unsuccessful prompts was of limited relevance. She noted that questions going to the substance of publishers' investigation will be of limited value as compared to the fact that any query led to positive results. Because Judge Van Keulen had already ordered the production of quantitative statistics, such as ratios of successful to unsuccessful prompts, she concluded that Anthropic could conduct effective cross-examination without accessing counsel's mental impressions. As a result, Anthropic's requests for production of all pre-suit prompts and outputs were denied. As for the 5 million record sample, which is quite a large sample, Judge Van Keulen reiterated that if the publishers were supplying the numerator, Anthropic was entitled to discover the denominator. Judge Van Keulen explained that disputes over how to categorize certain outputs, such as allegedly hallucinated lyrics, did not negate Anthropic's entitlement to meaningful statistics. So to resolve the impasse, she ordered the publishers to provide more granular statistical breakdowns across all 3 investigative contexts, including counts of positive results, disputed results, successful guardrail invocations, and other non-infringing outputs. So Tom, given the number of copyright infringement cases against AI companies, do you expect we'll see a lot more of these types of disputes over whether the AI company can discover the plaintiff's prompts?
Oh, absolutely. I mean, in just doing some quick background research, the phrase I kept hearing over and over again was prompt manipulation as a core defense. And more companies are doing that. To resolve that, the courts need the exact number of prompts used and the number of attempts and some sort of way to determine whether the output was typical or artificially induced. We've had a number of big cases, Tremblay versus OpenAI and the New York Times versus OpenAI. I thought Judge Van Keulen, though, said it really well, first of all, most succinctly by saying she was invoking the fairness principle. She then had to muddy the waters for those of us who are mathematically challenged by talking about numerators and denominators. I had to dig out the book there. That was the dictionary there, because that not one of my strong suits. That was the point in the 6th grade when they got to that my math career ended, which is also the same year that I first saw a curveball in Little League, and my baseball career ended. But she said, none of that negates, quote, Anthropic's entitlement to meaningful statistics, end quote. So I think that fairness principle is what's going to be the ruling guideline going forward.
Yeah, I guess with regard to numerator and denominator, I guess you could call that divide and conquer. So,
oh, no, please.
Anyway, Judge Peck, do you agree with the court's ruling to grant the request regarding the post-suit investigation, but not the pre-suit investigation?
I do. The post-suit investigation is what the expert is going to testify to. And therefore, what was done is, needs to be inquired into. And it's not what an attorney is doing. So there's not a question about attorney-client privilege or work product. I think some people may try to extend this to the prompts that lawyers generate. If they use AI for document review, I think this is very different, and that this result would not carry over, in my view, to that area. It's what was the expert doing? That's something that always is entitled to be inquired into.
Yeah, absolutely. I couldn't agree more. We're still waiting for that. That case involves the use of prompts for document review and what will happen there. So definitely we will cover that when we see one. So Mary, do you think the granular statistics that Judge Van Keulen ordered will set a precedent for other cases where an AI company is requesting information about the plaintiff's prompts and outputs?
Oh, I do. We're all trying to figure this out. And here the judge put out some quantifiable factors, and also put out some guidance as to what's appropriate for attorney impressions, what's appropriate for testifying witnesses. And then I'll just add, I think we're going to see some more consulting witnesses come up. In the last couple of years, that role, consulting witness and testifying witness, has sort of compressed into one person. But I think here, this is an invitation to separate them.
Mm-hmm. Yeah, absolutely. No, I agree. And for those of you who haven't already checked out the case does go into specifics on the specific statistics, easy for me to say, that are required. So definitely worth noting, because we may see other cases like that with that type of information being provided. So very interesting case, and I'm sure we'll see more of them, hopefully, probably this year. All right, so here's our second deja vu all over again case. We covered the previous ruling a couple of months ago, and covered it again last month in our Cases of the Year webinar. In that ruling, Arizona Magistrate Judge John Boyle stated, "The court will not excuse defendants from any efforts to produce contemporaneous hyperlinked documents outright simply because they elected to use a suite of cloud-based web applications that would make that process difficult. Turns out, discovering contemporaneous hyperlink files is hard. And when plaintiffs filed a motion to compel compliance, defendants asserted that the use of forensic email collector had not been productive, as FEC was only able to collect 0.4% of top-level executive hyperlink documents modified within 24 hours in Google Vault. Defendants also argued that of 112,000 plus total emails, FEC was only able to capture 7592 responsive emails with hyperlinks. Of those 7592 emails collected, many hyperlink documents still had modifications after the date the parent email was sent. In terms of burden, defendants stated that they spent 1,170 hours and over $200,000 using FEC for the 2 ESI custodians. This translated to a $425 per document price tag for using FEC, which was quote unquote 105 times more expensive than using traditional ESI discovery techniques. In light of defendants' findings on the burden of using FEC, plaintiffs revised their request, specifically requesting that they may choose 1,000 responsive emails from all 25 ESI custodians that defendants shall run through FEC to find the most contemporaneous version of hyperlinked attachments, with the opportunity to request further production through FEC were this new search to prove fruitful. Judge Boyle stated, "The court finds the best way to proceed on this issue is to strike a fine balance between burden and benefit. Namely, plaintiffs may select 250 responsive emails that defendants will be required to run an FEC search upon to find the most contemporaneous version of hyperlinked documents contained in the parent emails. This search is not limited to the 2 previously selected ESI custodians. Rather, plaintiffs may select any 250 responsive emails from any of the 25 identified ESI custodians." He added, "This order does not limit nor extinguish defendants' obligation to provide any and all responsive parent emails and their hyperlinked attachments to plaintiffs, but also said defendants shall provide the most contemporaneous version of all hyperlinked attachment from responsive parent emails using traditional ESI discovery techniques," which he defined in a footnote as a Google Vault search used without FEC or a script. In other words, defendants are not obligated to make and use a script in their search, nor are they obligated to use FEC beyond the 250 documents. Wow. So he also rejected plaintiffs' request for a reverse search of emails based on production of all non-privileged responsive documents within the ESI custodian's Google Vault collection, stating, "Instead, the court will allow plaintiffs, once all responsive and non-privileged documents in the ESI custodian's Google Vault collections are produced, to select 200 documents that defendants will attempt to locate a parent email if one exists. If a parent email exists, defendants shall produce it as long as it does not contain privileged information. Such limited search appears proportional to plaintiffs' needs of knowing who knew what and when, but will not be unduly burdensome for defendants." So, Judge Peck, we've seen a few cases now where the end result decided by the court is for the requesting party to request hyperlink files for a certain number of emails instead of producing them for all emails. Given those precedents and the current technical challenges, would you as a judge try to get parties to that point from the outset instead of going through the exercise like Carvana did here?
Well, anytime a judge can get the parties to agree on something, that's a good resolution. However, if it's not looking for party agreement, but sort of insisting do it this way, but let's skip all the preliminary steps, if it were a technology that wasn't changing, then, maybe the writing's on the wall and that's what the court should order. But since the technology does keep changing in this area, excuse me, and it's somewhat dependent on how the company's data system was set up, as a judge, you'd want a clear record on what can and can't be done, proportionally in this area. Certainly, we are past the day when the parties could say, well, it's a hyperlink, that's hard, so we're not doing anything with hyperlinks. But you need to have a record if the court is going to order something in an area where things are changing. And one lesson from Judge Boyle's decision is he is not going to make the parties boil the ocean to get every hyperlink document.
Ooh.
Boil the ocean, that was a Austin on there.
Wow.
Nobody thought, okay.
Man, I can't believe I missed that one.
We were still cringing.
Yeah. kudos to you, Judge Peck, on that one. I can't believe I missed it. All right. So, Mary, do you think Judge Boyle's ruling that defendants could use traditional ESI discovery techniques for the rest of the hyperlink files gets them off the hook for those files, given the current limitations within Google Vault?
Well, as Judge Peck said, I'd say off the hook for now, but they better not need to use an email with one of those hyperlinked attachments that you can only get with the FEC, because if they can use it, then why wouldn't they have to go in and look for other instances of contemporaneous versions? So I think they're off the hook, depending on how long the discovery's open.
Yeah. And that definitely seemed to kind of change things. So, Tom, as I discussed in discussing the case, defendants provided several statistics to back up their claim regarding the burden associated with using FEC to discover contemporaneous hyperlinked documents. Does this change your thinking regarding what producing parties should be expected to do in responding to requests for these files?
Well, no, I go back to your initial statement at the top of this case, that we've heard judges say before: if you choose a product that can't do it, then don't come in and complain you can't do it. I'm paraphrasing that, of course. I think a lot of the discussion here is very similar to what Judge Peck described in the very first case about boilerplate language. There's a ton of discussion out there about hyperlink files in products and what can do what. This shouldn't be that big of a surprise to people that these products are struggling to get these things done. But on the reverse side, both Google with Google Vault and Microsoft are working assiduously to improve that process and to make their own internal products work on their own to handle those sorts of issues. So I think the real key here is, I have a product. How long have you had it? And how many times have you tried to use it? And have you checked on what's available now, including updates to that particular product? And I don't mean to single out FEC by any means. This is a horribly difficult issue, and they just happen to be the product that was used here. I will say my boilerplate response to all of this, however, is you should have grabbed the document at the time that the preservation obligation arose. I'm seeing too many of these discussions come out when it's production time. And my response to that from the requesting party's part would be, why didn't you go and get that original document when the duty to preserve arose and you preserved the original email?
Sure. Yeah. Although sometimes it's hard to kind of draw the line on where the duty to preserve begins and ends. Because you don't.
Agreed.
Yeah.
Agreed.
Yeah. Yep. So your custodian may have a link to a file, but someone else may have sent a link to a file that they're not a custodian. So that's always a challenge.
It's a sticky technical question, but I'll just reiterate quickly. Both Google and Microsoft are working very hard to try to get some resolution to this issue.
Yeah, and I expect we're going to continue to see evolution here. I almost thought this was going to be the first time we're going to cover one of these cases and not get a question from the audience, but Ryan gave us one. If you're producing documents in G Drive and company policy is only to use G Drive for business docs, would hyperlinks in chat or Gmail necessarily need to be connected reference to the collected documents? I mean, I certainly think so. I think you've got, but again, the question is, it's not just the file, the files, it's the contemporaneous version of the files, is the file that shows who knew what when. And I think that's the next layer of challenge that we're struggling with, and this case illustrates that.
Yep.
So yeah, we'll continue to see cases, I'm sure, like these, and we'll certainly cover some of them. And we do have one case left, so we'll move on to it. In our last case, which was suggested by Judge Peck, the proposed ESI protocol from Mercedes-Benz Group AG contained three contested provisions: a definition of foreign personal data, permission to redact such data and objectively irrelevant information from produced documents, and an exemption from identifying custodians where foreign privacy laws allegedly applied. MBG argued that EU GDPR restrictions prevented it from producing unredacted names and contact information of EU employees unless plaintiffs first demonstrated that such information was necessary to their claims, proposing a so-called layered approach to production. Georgia District Judge Sarah Garrity rejected this interpretation, holding that the plain text of the GDPR does not support the strict and narrow interpretation of necessary advanced by MBG's expert report, and observing that the GDPR does not define necessary in the manner MBG suggested. She also noted that MBG cited no persuasive authority beyond its own expert opinion, showing that European tribunals or regulators had adopted MBG's view and found MBG's approach inconsistent with established U.S. discovery principles because it would improperly shift the burden to plaintiffs, explaining that MBG's proposal would likely open the door to additional litigation time and expense, forcing plaintiffs to review redacted materials and then justify why obscured information should be disclosed. She also emphasized that under U.S. law, the party resisting discovery must provide the court with information of sufficient particularity and specificity to allow the court to determine whether the discovery sought is indeed prohibited by foreign law. Applying a five-factor balancing comedy analysis, Judge Garrity concluded that 4 of the 5 factors weighed against MBG's proposed protocol. She also stressed that the United States undoubtedly has a substantial interest in fully and fairly adjudicating matters before its courts, which is only possible with complete discovery. Allowing MBG's preemptive redactions would undermine the interest advanced by the federal rules of civil procedure and this court's routine discovery process. She then turned to MBG's request to redact objectively irrelevant information, again siding with plaintiffs, noting that relevance-based redactions are heavily disfavored, and pointed out that the parties had already entered into a stipulated protective order, including an attorney's eyes only designation, and that MBG has not shown that the protective order is insufficient to protect its interests. However, Judge Garrity denied plaintiffs' request to compel MBG to disclose the names and contact information of all custodians in its initial disclosures as procedurally improper and substantively unsupported, explaining that Rule 26A requires disclosure only of witnesses and documents a party may use to support its claims or defenses. So, Mary, do you think MBG could have made a better argument to limit or exclude production of personal data? If so, how?
Well, I think in essence, they relied on an expert witness rather than relying on their own ability to cite opinions, precedent, authorities from a legal perspective, as opposed to an expert witness perspective. And they said that MBG has not shown that the protective order is insufficient to protect its interests. They'd have to say more about how it was insufficient rather than just a blanket statement.
Yeah, no, absolutely. So, Tom, the one ruling that went against the plaintiffs was their request to compel MBG to disclose the names and contact information of all custodians in its initial disclosures. Shouldn't they have a right to know who the custodians are so that they can request discovery from the ones likely to have discoverable information, as we saw in the earlier custodian dispute case we discussed?
Well, sure, in a general sense, but I think Mary just hit it on the head. You gotta tie this to what information or what data is it that you're trying to use. The parties are required to disclose the names and contact information of witnesses that they may use to support their claims or defenses in their initial disclosures. And then also required to disclose a copy or a description by category and location of all documents or tangible things they may use to support their claims or defenses. So you look at that description of the documents or tangible things and see if you can come up with the list of or see which custodians apply. But you know, a list of all custodians, I think, is overbroad. I mean, what would that list look like from Mercedes-Benz, right?
Yeah.
So, you know, it's got to be reasonable.
And I would add that, you know, it was hanging its hat on a particular rule, nothing would have prevented it, Mercedes-Benz from doing the plaintiff, I guess, from doing an interrogatory or something that would be specifically aimed at what custodians might have relevant information untied to the initial disclosures.
Yep.
No, fair point. Absolutely. So Judge Peck, while Judge Garrity said relevance-based redactions are heavily disfavored, we covered a case a couple of years ago from Judge Catherine Parker where she allowed them. So when should they be allowed versus not allowed?
I mean, they should be allowed, as in the Parker decision, where it involves a discrete area. So in her case, it was discrete columns in a spreadsheet. I remember in the good old paper days before we got into all sorts of hyperlinks and everything else, we would have to produce documents, paper in those days, like board minutes. And so what became the way to do it was you leave in all the titles of sections in the board minutes and redact the information under the categories that was not relevant to the lawsuit. That means, opposing counsel can say, this looks relevant to me, and you could have a discussion about it. The Swiss cheese approach to redactions, where you have an email and you redact the name here and there, and all of that makes it very hard for anyone to deal with it. And the other thing, and this is a problem, unfortunately, under the GDPR, personal private information includes the name, the email address, and similar identifying information about corporate employees. So, we have a question here. What about pseudonymizing? It makes a big difference whether a suggestion in an email to do X came from somebody in the C-suite versus, a lower level employee or whatever. So that doesn't really work. In one of these years, we will come up with some way to deal with the privacy considerations in Europe and elsewhere, and how that applies when you're talking not about personal information, as we would call it, but corporate information. But at the moment, we're still struggling.
Sure. Very quickly, if there hadn't been a protective order here, do you think that would have changed anything?
Well, one can always get a protective order. So if there wasn't one in effect yet, then there should have been an application by Mercedes-Benz for an appropriate protective order. And I've seen, and I believe Sedona Working Group 6 has a proposed U.S. protective order that allows the, corporate employee names, et cetera, to be classified as confidential under the protective order.
Mm-hmm. Yeah, absolutely. Great resource reference there. And, they're a German company, so they're probably opposed to the Swiss cheese approach. So with that, we'll move on to the contacts page. And we do have a date for our next webinar, which is Back to Another Manic Monday, just under 4 weeks from today on February 16th. February is for lovers of eDiscovery case law. So with that, I'll say thanks to Mary, Tom, and Judge Peck as always, and I'll turn it back over to you, Mary.
Thanks, Doug. And we thank you, Tom O'Connor, and the Honorable Judge Peck for this great, insightful presentation. Thank you to the EDRM community for your kind attention and great questions. If you enjoyed today's presentation, show our faculty some love, explore the resources at the bottom of your console, and share an emoji or reaction. We look forward to seeing you next time on the EDRM Global Webinar channel. Thank you.
Bye, everybody. Thank you.
Everybody.
Thanks a lot.